So we're on the record. And Ms. Lewis, you have something you want to say about the slide deck?
Yes.
Okay.
We have an objection to slides 40 and 41 of the slide deck. The opinions offered within. So perhaps it might be helpful if you had that up, and also page 44 of the expert report of Cliff Hamal, April 17th, 2023 as well, although I might not refer to that.
And that's of the initial report?
Yes. So at slide deck 40, Mr. Hamal gives a opinion, a bold conclusion, if you will, on a matter that was not challenged in Professor Stiglitz's testimony, which is that approximately 30% of uncollected economic rents are collected indirectly by the Crown through income taxes. So that opinion was not challenged by Ontario or Canada when Professor Stiglitz testified. It's unfair not to.
Sorry, what did you
So I was reading from slide deck 40.
Yes.
The second bullet point where they say at trial, Professor Stiglitz asserted that approximately 30% of uncollected economic rents are collected indirectly by the Crown through income taxes.
Yes.
So Professor Stiglitz did in fact testify to that. But he was unchallenged on cross-examination, and nowhere in any of the Crown's reports is there a response to that. And then the three bullet points underneath that on slide 40, or sorry, the two, as detailed above, this 30% assertion is wrong for hydroelectricity and the value could be as low as 0. And then the subsequent bullet point, even if the 30% figure were true, the Crown would not be collecting 70% of the uncollected economic rents. So those are new opinions. So
each of those three?
Yeah, yes.
Okay.
I mean, quite honestly, even the first bullet point where it purports to cite Hamal, or the bullet point does cite Hamal initial report, paragraph 111 and 113. The statement theoretical hydroelectric uncollected.
Whoops, I'm not getting where you are.
Sorry, I'm at just bullet point 1 on slide 40.
Yes.
Where he says theoretical hydroelectric uncollected economic rents are unlikely to be excess profit to any entity.
Yes. At
Paragraph 111 and 113. And now I'm summarizing, and I'm sure if I get this summary incorrect, my friends will correct me. The summary is that Mr. Hamal disagrees that there is a greater economic rent, which exceeds the Crown's ability to capture it as revenues, that supports the augmentation of payments under the treaty. That was the first line of paragraph 111. And then he goes on at paragraph 113 to say, the existence of such value is not a source of conservatism because that value is not relevant. So my summary of those paragraphs is that Mr. Hamal concludes that value isn't relevant. He doesn't conclude or conduct any analysis with respect to how much the Crown might recapture as indirect revenues. I mean, he goes on to say at the last sentence of paragraph 113, in addition, practical considerations of how such rents might be collected are relevant to understanding what actions were taken and perhaps should have been taken in meeting the Crown's obligations. It's clear from my reading of his report that he hasn't undertaken that analysis. So today, I was very much taken by surprise with no notice that Mr. Hamal, pardon me, was intending to testify to this matter. He's not an economist. After much discussion.
So I really need to understand what it is that he's saying that you are objecting to.
I'm objecting to the opinion that the 30% assertion of uncollected economic rents are collected indirectly by the Crown through income taxes. He says that is wrong for hydroelectricity.
And he said that's wrong
in bullet point number 2 from the bottom on slide 40.
So of course, these bullet points are, there's one and then there's 1, 2, 3 and 2 and
Yes.
then 1, 2, 3.
So if you look to the main bullet point, the second one that starts at trial,
Got it. So
Then-
2 sub,
2, if you will, as
sub two.
detailed above, that starts as
Got it.
detailed above.
okay. This 30% assertion is wrong.
Yes. So in our opinion, that is a conclusion, a bald conclusion. There's been no analysis. There's no report in which he discusses that and explains his conclusion. We consented to the witness testifying to his 2 reports, but not to matters outside his 2 reports. In his report, he did not talk about what percentage of rents over and above NCRRs are captured by the Crown. And it's wrong for this rebuttal evidence to be sprung on us this morning with no notice. It has been months since Professor Stiglitz and Mr. Hutchings testified. And this evidence should have been raised before today.
You're saying firstly, it could have been the subject of cross-examination.
Yes, that is my first point. It should have or could have been if they intended to challenge Professor Stiglitz on this, it should have been the subject of cross-examination. Then my second point is there was no notice. This was sprung on us this morning. And I don't quite understand why it was left to the last moment. Ontario provided us with new redacted reports from this witness last week. So in doing those redactions, they could have also proposed amendments or sought leave for a further surreply report if that's what they thought was appropriate.
So you say, among other things, you are denied the opportunity to surreply.
Yes. I also say that in accordance with Rule 53.03, 2.1, sub 6, the expert's reasons for his or her opinion, including a description of the factual assumptions on which the opinion is based. I say there are none.
Mhm.
A description of any research conducted by the expert that led him to form that opinion. Again, I say there are none. And a list of every document, if any, relied on by the expert in forming the opinion.
Are to be included.
Yes. So I say he can't, or I mean, the rules say that you can't testify to a bald conclusion.
So you
without-
say this is inadmissible. These points in evidence are inadmissible.
Yes. Now, I hope I have a solution. Perhaps not,
I like
but
that.
um,
Have you talked to your friends about this?
I identified to my friends that these sections of the slide deck, I objected to, but we have not had a detailed discussion about how to resolve.
Okay.
So if these new matters, or pardon me, perhaps before I go to the solution, I would also like to identify what I say is objectionable about slide 41. So in this slide, Mr. Hamal is repeating Mintz and O'Riordan's testimony. So particularly if we look at the second main bullet point on slide 41.
Yes.
Professor O'Riordan testified about rents being attributed to other entities, such as to exceptional managers, technological improvements, efficiencies, lower costs, and potentially higher rates of resource exploitation, in addition to the inability to tax 100% of rents in the first place.
Mhm.
So, and then he goes on, we also find the second bullet point objectionable because it seems to, again, just be an excerpt of what Professors Mintz and O'Riordan testified to.
So
Now,
it's not new opinions, it's just a repeat of
of
earlier
Mintz and
evidence.
O'Riordan's testimony, that this evidence and this witness testifying to this evidence adds nothing. It belongs in argument, and that's Ontario may make those arguments if they wish. But Mr. Hamal is not an economist. Whatever Professors Mintz and O'Riordan testified to on cross-examination, they testified to. And without notice to us in an amended report that this witness now intends on relying or offering an opinion on Professors O'Riordan and Mintz's testimony.
Or do you say he's relying on it or adopting it as his own?
Either, it's unclear from the slide, but it's wrong to raise this evidence through this witness. That is a summary of my complaints with respect to slide 40 and slide 41.
Mhm.
Now, perhaps, hopefully, a solution. If these new matters are so relevant to Ontario's case that they feel they need the evidence in the record, then the proper procedure for them is to seek to file a supplementary report with the proper analysis and supporting documentation that is required by Rule 5303, and on which the opinion is based. The admissibility of the report can be argued later when we get the report. And on the other hand, if this opinion is not critical to their case, then this witness should not be permitted to testify to it because it goes beyond his reports and his expertise and lacks probative value.
Thank you.
So unless there are questions, those are my submissions with respect to this issue.
Thank you. Who's up? Let me catch up with one thing.
Of course.
Go ahead. Thank you.
Thank you, Your Honor. I believe there's been, I'll characterize it as a misreading. Let's start at these two items, bullet points that my friend is objecting to aren't new issues.
Page.
The slides 40 and 41.
Okay. Both. So you're replying on both.
Yes. They are not new issues or new matters. What Mr. Hamal seems to be referring to are examples. So if we start at slide 40, bring this one up. So what happened is that on the stand, Professor Stiglitz mentioned this 30% recovery rate.
Yes.
This 30% was not in his reports. The first
In
time
whose
it-
report?
Not in his reports.
Not in Professor Stiglitz's reports.
That's right.
Okay.
Joint reports of Stiglitz and Hutchins.
Got
Just
it.
to be more clear.
Mhm.
So this 30% was first raised on the stand.
Mhm.
And I disagree with my friend that it wasn't a cross-examination. I have extensive cross-examination of Mr. Hutchins, but let's leave that aside. So what we're talking about is an example raised by Professor Stiglitz about this idea of additional benefits to the Crown. That's what happened. And what we have done, we have called an expert who is now able to rebut that. But that is not a new issue
I don't think it was described as a new issue.
or a new matter,
A new assertion by this witness.
but it's not. So if you go to the initial report,
All right.
sorry,
Could you just speak up a little bit?
Oh.
You're quite low.
I'm sorry. And there are other locations, but if you start at paragraph 111,
Yes.
I'll just read that first sentence. I disagree that there was some greater economic rent.
Yes.
And that position is replete through his entire SIR reply and through his initial reply. And I don't want to waste the course of time by going through every single instance.
All right. Let's say let's say he does assert, I disagree that there are some greater economic rents.
That's
Does he anywhere assert that Professor Stiglitz is incorrect about a 30% recovery rate. And Ms. Lewis is on her feet.
I'm sorry, just to be fair to the court, I think it's appropriate to read the rest of that sentence because in that sentence, it's not that he's saying that there is no greater economic rent. He's saying which exceeds the Crown's ability to capture it as revenues, hyphen, that supports the augmentation of payments under the treaty. So that sentence or the latter part of that sentence qualifies his opinion. I disagree that there is some greater economic rent.
Okay. And you were reading from paragraph 111.
Yes, the first sentence.
Thank you. So you can answer that in a moment, Mr. Hong, but answer my question first, if
I
you will.
will. Sorry,
My question was, does the witness assert at any place that the 30% recovery rate, as you shortened it to be, is wrong?
no, because it first was raised on the stand by
Right.
Professor Stiglitz. That's the reason. We didn't have an opportunity to file another report after Professor Stiglitz took the stand.
All right, but so you agree that's the first time he said that, and you say your answer to that is we haven't had a chance to file another report.
Right, but the issue was already raised by Mr. Hamel in his reports. What he's doing now is now responding to the example that Professor Stiglitz raised in his testimony,
Right.
which we feel is the most assistance to the court. Obviously, if you have experts speaking to their issues and they don't quite match up,
Mhm.
obviously it's better if they respond to the precise examples used by one expert to the other. I suspect Mr. Hamel watched some of the testimonies and probably listened to some of your questions, and he took it proactively to respond specifically to an example that Professor Stiglitz used.
Right, so you had the opportunity to say to the plaintiffs, we want to respond to that specific example. Our witness wants to respond to that specific example. We can file a report, we can fight about it, but you don't wait till it's on the stand to let them know. In
True,
2
but
months.
I'm sorry, I didn't mean to cut you off at the end there.
Go ahead.
It's true, but again, he's already responding to the issue and matter at hand. So there were many examples brought forward by Professor Stiglitz about carbon reducing trees, about widgets. I mean, it wasn't the point to file a report to respond to every single example in oral testimony. I don't remember how many days Professor Stiglitz was on the stand. It was maybe 2 or 3. but
None of us can.
there were many examples, and that's not really helpful to the court to repeat the same arguments, trying to say, here's example A on day 1, example B on day 1. The matters and issues have already been raised by Mr. Hamel, and again, he should provide assistance to the court by making a direct response.
So you say that the initial Stiglitz reports was a bare assertion,
That's correct.
and that in Mr. Hamel's report, there's a bare rejection of the bare assertion,
I wouldn't
And
call
that-
it bare, but sorry.
and that in oral evidence, Professor Stiglitz gave an example of his assertion, and now the witness seeks to disagree with that example.
Right.
You're
He
saying
already-
that's the chronology here?
Yes, he already disagreed with the main point, but when Professor Stiglitz was on the stand and gave, oh, by the way, there's a recovery rate of about 30%. And now that his opportunity has been on the stand, come to the stand, he's responding to that example using the same point that he's already raised in his reports.
And do you say that that Professor Stiglitz's opinion, you say it was heard on the stand for the first time, wasn't his report? Do you say that it was backed up by data or research or anything?
It wasn't specified in any of the reports.
So is that not a point for you to argue?
Well, we called a witness who can actually speak to it.
No, but that's evidence. Is that not a point for you to argue? He gives this opinion with nothing to back it up. We didn't answer it. Our reports were already in. There's nothing there. It's a bald assertion.
Right, but we didn't know that he was going to expand on it in his oral testimony.
Right,
So that arose live on the stand.
right. Was there any cross-examination on it?
There was cross-examinations on benefits to the Crown generally because
Right.
there were so many examples. So
But this particular assertion we're talking about, this 30% recovery,
there was cross-examination on what it meant. Like,
Right.
Mr. Hutchins didn't do an apportionment for that 30%. He didn't calculate the benefits directly connected to it, revenues. So there was on the issue, but not specifically where the 30% came from.
Right.
If that makes sense.
So it was new. You didn't challenge it for being new. Is that right?
Specifically, no, just the concept.
Isn't that where we should go with this? You should argue it. But I don't want to run a trial. I don't want to run new facts, new evidence.
It's not new evidence.
Well, it's new evidence from Mr. Hamal, is it not?
No.
On the 30% recovery?
So what the intention is that he's going to make the same points he was always going to make,
Mhm.
and to help the court, he's going to apply that to the example
It's not going to help me.
specifically raised by.
It's not going to help me if it's not part of if it's not covered by both. So if what you're saying is Professor Stiglitz didn't back it up, maybe you didn't cross-examine on it, but he didn't back it up. That's your argument. That's what I'm thinking at the moment. If you make me, I'll go back and read the evidence, but that's what it's sounding like to me. I do not want to have new, what I think is new evidence here. If you say what Professor Stiglitz did in his oral examination was new, there was a time and a place to bring that to the court's attention and to challenge him on it, to say it's inadmissible. But then saying, no, we're going to take it. We're going to say, okay, great, it's admissible, it's there. Now we're going to bring evidence contrary to it.
Again, it's not evidence.
This is not going to be, what's in the slide deck is not going to be evidence?
He's applying what he's already saying
Yeah,
specifically to that example, just to make it more clear.
but you want me to accept it.
That's right.
What's evidence? You want it
Again,
to be evidence, I think.
his opinion is the same, the issue is the same, the
Right.
matter is the same. It's the specific example that we're talking about.
Right. And it would be new evidence on that example.
It's new, right, in response to that
But,
specific.
right, and you're saying it's new because Professor Stiglitz brought in new evidence.
Right.
Okay,
But that's, again, is an example, not specifically evidence. So the rule says issues, not evidence. 5303. An expert witness may not testify with respect to an issue, except with leave of the trial judge. I won't read this, my friend already read the same thing. And they can also do so with leave. But again, we're not talking about a new issue. We're talking about a specific example, just like the widgets or the carbon trees, all these examples are brought up. So he would respond to it generally. He can use the same ones in his things, but to be more helpful, he can say, in that specific example, that Professor Stiglitz brought up in his oral testimony, this is how I would apply. So if you look at the second slide, slide 41.
and I don't have the rule before me, so I'm going to ask you to
Oh.
pass it up when you're finished.
Okay.
Oh, and I'll just make a note.
Of course.
Just right here, Scott. Thank you. Okay, go ahead.
Okay. If you turn to slide 41,
Mhm.
this was the second objection from my friend in regards to the last bullet about the evidence of Professor Reardon and Professors Mintz.
Yes.
Again, this is not a new issue or matter. What's being spoken about here is about the problems of collecting rents.
Mhm.
And that issue is well aligned. His report and his server report speak to that issue. You can bring up the server report, section 3.
The issue, I don't think the objection is to what he's speaking about, is that he's repeating the evidence of other experts.
Right. And he's not in the stand, but it wasn't to rely upon it. It's saying, here's my issue, and the other experts have also raised the same issue.
All right, so that's not
I think that's what we're ending up.
right. So you would agree that it's not for him to tell me what the other witnesses have said.
Oh,
This
no,
is not-
it-
This is not argument.
That's right. He's not relying upon that as part.
Well, no, not just not relying on it. He's not giving it to me as evidence.
That's right.
It's not evidence. It's an argument.
Oh,
If all
no,
he's saying is the other experts have said this,
the same thing.
that's for you to say at the end of the day.
That's fine.
Thanks very much, Mr. Hamel, but everybody's got their job, sort of stay in your own lane. Is what I would say to that.
That's
If
fair enough.
that's your explanation for it.
It's not a new issue, but you're right. He's just saying other experts have said the same thing.
Okay, so let's. I'm not exactly sure anymore what oath helping means, but that might be what this is. They've already said it. We've got it. You're going to emphasize it in your submissions. Okay. Okay, let's go back to this, and I'm just looking at the rule.
Sure.
What did you say it was? 2.6?
3503, it should be in the middle of the second page there.
Right, 5303, is it?
5303, sorry.
If I can be at all of assistance,
Yes.
I read out 5303 2.1 sub 6,
Ah,
which,
Thank you.
which is in reference to an expert providing a report.
and is that where you're directing me as well, Mr. Hong?
I believe so. I handed up my copy.
If I can be helpful, I think my friend actually read 53.03 sub 3. An expert witness may not testify with respect to an issue. I believe
Okay,
that's the
I
one.
think that's it.
Yeah, so
Okay.
we were actually reading different sections
Oh.
of the rules.
All right, so Ms. Lewis was relying on 53.03 sub 2.1 sub 6.
Yes.
And the nature of the objection is that the expert's reasons for his or her opinion do not include what is required, and that is they don't include a description of the factual assumptions. They don't include a description of any research that was conducted to come to that opinion. So that's your complaint.
Yes,
Thank you. Okay, and you, sir, are saying that under sub 3, 5303 sub 3, there's a prohibition against testifying with respect to any issue unless the issue is boom, 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 and you have included those. So you have answered sub 3. Ms. Lewis bases her objection on sub 2.1 sub 6. Do you want your rules back? Would it help you? Thank you.
May I speak to that?
Yes, please do.
So I do not believe it falls within any of those categories in the first rule.
You do not believe it contravenes any of those?
That's correct.
Okay, go ahead.
It's not a factual assumption that he used to come to his conclusions. He's already done that.
No, I think the objection is that he doesn't set out his assumptions. He makes an opinion, he has an opinion. He doesn't set out the assumptions on which it's based or the research on which it's based.
But he does through his reports, which we will go through this afternoon.
Okay,
So
and that particular example though, of the 30% recovery,
it's not a factual assumption. It's not a factual assumption.
right? The
He's
que-
reached
so
this-
It's an opinion.
He already has an opinion. Now
Right.
he's just applying it to this example.
Yes, and that applying it to the example, is an opinion
Yes,
that Professor Stiglitz is incorrect or wrong when he talks about a 30% recovery rate.
yes.
That's an opinion you want in evidence on the record,
Right. He's already saying he's wrong.
right? But just, am
Yes.
am I right with that?
Yes,
Okay, it's an opinion. So the objection is that to support that opinion, he must provide the assumptions on which it's based and the research he has done to back that opinion up.
yes. And he's going to explain this. He
With
reached-
respect to the 30% recovery rate?
Well, it applies to many examples, right? Some.
No,
cite
no,
others.
I'm only talking about with respect to his opinion on the 30% recovery rate.
Right. He's not addressed the specific 30% in his reports, but his.
But I'm just about that opinion. Does he set out his assumption, the assumptions he relies on, or the research he's conducted with respect to the 30% recovery rate?
He sets out his assumptions and factual basis where he reached a conclusion. And that conclusion can apply to many examples, including 30%.
Okay.
So you can choose to reject or accept that analysis, but there's nothing new there in terms of how his assumptions, or the facts he uses to reach there.
And are you going to show me in the report where he sets out or discusses the 30% recovery rate and any assumptions that he relies on to come to his opinion, or any research that he has conducted to come to his opinion?
Again, he doesn't specifically refer to the 30%.
Yeah.
Because it wasn't in the initial reports.
Right.
So conclusion's the same.
No, you don't have to tell me anymore what your thing is. So I don't say they're the same thing. You want to make a point that a particular example is wrong? That's an opinion. And the opinion has to be made on the requirements in the rule. If he wants to make give us a general opinion, because he was answering Professor Stiglitz's general opinion, I'm going to rely on you. We have the assumptions on which that opinion is based, and we have the research on which that opinion is based. So that's where he is. But not with respect to a specific example, because we don't have that research. And you can argue, I don't know what your argument is with respect to Professor Stiglitz's opinion in the evidence, whether you have an objection that nor did he set out his assumptions or his research, which maybe could have been done in cross-examination. But in any event, you can still do that in argument as a reason why that example should not be accepted as his opinion. If you say it contravenes the rule. But this opinion, if this opinion on the slide deck is proffered in oral evidence, it still has to meet the admissibility requirements. Not the general opinion. The general opinion looks like, sounds like, is and will be properly before the court. He could be cross-examined, for instance, on it, I think, even on the example,
right,
to show that his general opinion is wrong. But I don't think he can bring in his very specific opinion without backing it up. He'll be ready for cross-examination, though, if by chance you want to bring it up.
which I highly doubt. So I'll leave to your honor to make a ruling.
All right, yeah. Any questions that seek to elicit the answer with respect to the 30% recovery rate the objection is sustained. You can't ask those questions to seek to elicit that opinion. Okay, and then when we make this an exhibit, we can deal with how we deal with the slide, wherever it is, 40.
40.
And the same with 41, okay? So I don't think there's and the same with any questions relating to the other. If you have questions that seek to elicit these answers that Professors Mintz and O'Riordan already said this, or they agree with me, those are not permissible questions. Now, did you hear any other evidence that backs you up? Those are not permissible questions. Okay. Thank you very much. Now. What? Oh, yeah.
Please.
Afternoon, sir.
Good afternoon.
Afternoon, Mr. Hamel.
Good afternoon.
Hope you were able to find some place for lunch.
I enjoyed Tim Hortons. I can't imagine anywhere else I'd rather be.
It's the big challenge of this trial.
Pinnacle Canadian lunches. So I think we are at slide 17.
Yes.
Actually, we'll go to slide 18. So you've titled this section 3, Economic Rents. And on this slide, slide 18, you've titled it Overview, Hydroelectric Economic Rents. Now, can you just remind the court, why are you addressing economic rents?
Much earlier today, we went over the 2 instructions I had from council, questions I was to answer. And the second one concerned this subject, economic rents, and testimony of Professor Stiglitz and Mr. Hutchins.
Okay, and you can explain your overview here.
Yes, I want to present how I went about presenting. I find this a complicated topic, and we always have to start everything all at once. But what I've done here is first go through a definition of rents. By the way, I'm not offering my own definition of rents. I'm working from that put forward by the other witnesses, Professor Stiglitz and Mr. Hutchins specifically. And then I go into their analysis and I find flaws in their analysis, and I will talk about that. So I do what are economic rents? What are the flaws in the analysis that's been provided? And that sets up the third topic, which is the relevance of this topic and relevant of economic rents and the analysis to the augmentation clause of the treaty. And I deal with that last after crossing off the other 2.
Let me just stop you there. So why do you apply Professor Stiglitz and Mr. Hutchins' definition of economic rents?
To do that, I would go to the next page. Well, the next page, you asked me what.
Why?
Well, I'm responding to their testimony. I'm looking at how they assert it should be relevant to this case, and I'm working from their definition rather than my own.
Okay.
Frankly, I think the notional concept of economic rents have many different definitions and many different perspectives. And I'm trying to, get focused on what they have presented and not get caught up in issues of definition.
I know that you were very careful, sir, when you began your evidence to say you don't purport to offer any legal opinions. But in this case, well, no, in all cases, the word relevance has a heavy and specific meaning. So if there's a better way for you to reject their use of this concept, if there's a better word, I'm hoping you can find one. And maybe Mr. Hong, you have one, I'm not sure. But it's hard for me in my mind to separate what you say is, it's not relevant to this case being anything other than my job.
Okay,
So it's just a tough one for me.
So
thank you for
perhaps-
that. And that's the last thing I want, I am trying to be careful to not
Okay.
do that. Yeah, my suggestion is, since that's just an overview slide, we don't worry about its existence there unless.
Not
we want-
worried.
Pardon me?
I'm not worried.
And then I'll try to be more focused going forward.
Okay.
So perhaps it'd be helpful if you could just explain what you meant by using the word relevance here.
Well, I start with the framework that they provide as to
Mhm.
why they think economic rent should be discussed here at all. And I look at their framework and the line they draw between this analysis and the augmentation clause. And I analyze that and discuss that in some detail.
Okay.
And you also say, using your word, and you say the relevance is questionable. So what do you conclude about the economic rents for hydroelectricity?
I think there's a potential of different perspectives on it. I also realize there is an element of legal determination that is outside of my scope. My conclusion is the net crown resource revenues that Mr. Hutchins calculated are water rentals, and they are applicable to the augmentation clause and the net crown resource revenues. And then after all the discussion of economic rents, it doesn't change my conclusion that those are the best numbers to use for consideration of that clause. But I say questionable because there could be other interpretations someone might draw, including legal interpretations of these issues. And I try to cover off those possibilities and talk about the analysis in greater detail, and so that it might be used in other ways.
Thank you. Now, on the next slide, slide 19, you have a subsection heading that says 3A, definition and determination of economic rents. So let's go to slide 20. Can you tell the court what you were conveying here on this next slide, slide 20?
I'm working through the definitions provided by Professor Stiglitz and Mr. Hutchins. They start, I quote them directly, the economic rent generated by a resource is the economic surplus created over the costs necessary to exploit that resource. That's the introductory definition they provide. And I will come back to that at the end of this presentation. But then they go into further definition, and I'm jumping down here a bit, that says, let me not do that. So that's the definition they provide at a high level.
Okay.
The next step is the Crown did not collect all possible hydroelectric economic rents through water rental revenues. That's true. They assert that. I agree with that. So that's there is a possibility for collection of more. But then as we work through these definitions here, they assert that economic rents could have been fully collected by the Crown. And we can highlight that first sub-bullet, which is from their report. Economic theory tells us that the full economic rent could be captured by increasing the water rental fee. That's a very specific definition of economic rents. As it applies to hydroelectricity, as it sets up its calculation and its application issues in this matter. That's their definition. I work with that. There are other definitions that could be used about rents that could not be collected by the Crown, rents that could go to other people. This is their definition.
Well, is it possible they use that definition because they want it to be, if it's one definition, if it's one allowable definition, you say they could have used others, but this one you agree with, Isn't that might be one of the reasons why they use that one?
It could be. I'm not, I sense that I'm sending up a challenge that I don't mean to. I'm accepting that as the definition here, and it's something to work with.
Okay.
What there are other definitions that have been used in this case. I'm using that one here so we could talk about their analysis and its role,
Mhm.
so that we know that that's being done. And it's certainly consistent with their analysis. It all makes sense, but I want to establish a toehold here that I'm working from this point.
Okay.
And so I provided it here, and the other sub bullets about they could have collected all economic rents, the full capturer's choice available to the Crown. All these things are the idea that it could have been captured, and I'm pausing a moment to make sure that that's really what I'm working with in my analysis, and it comes from them. And what it means is there's no greater economic rent value associated with hydroelectricity that's beyond this amount. I mean, if that's the definition, then there isn't some other rent value. And we need to be clear about where economic rents lie in the hydroelectric space.
So I just want to make sure this is clear. The court asked you if you agreed with that definition, and in your response, you said you accepted it for the purposes of your work. Can you explain if the distinction, or if there is a distinction?
I believe, to me, economic rents is a notional concept which has different perspectives, and people look at it for different purposes for different ways. If we were looking at economic rents having to do with patents or market power, we might come at it in different ways beyond what could have been captured by the Crown, for example. And so I think it is useful here. I work with it. I think it's reasonable here. I'm not opposed to it at all. And I'm not introducing a different definition.
I think you mentioned economic rents as a notional concept just now. Can you explain what you mean by that?
I mean that it's a concept that is, particularly in the economic space, it allows economists to talk about ideas, categorize things, and adopt public policy and things along those lines. And I'm drawing a distinction between that and practical definitions that are fully detailed that would allow precise calculations. I don't think that the notional value of economic rents rises to that level. In part because of the definitional differences that people have to the concept of economic rents.
Okay. So the next slide, slide 21. You titled it, Economic Rent Analysis Assumes Higher Water Rental Rates. Can you explain what you mean by that?
Right. So now I'm moving from the definition to an overview of the analysis that Mr. Hutchings did that was sponsored by both Professor Stiglitz and Mr. Hutchings. My understanding is Mr. Hutchings is the one who actually did the calculations. And so how they put this into practice and how they did their calculations. They adopt the framework of Gillen and Wen, two professors in Ontario that wrote a paper, 2000, that talked about water rentals as a going forward basis in Ontario around the time of the restructuring of the Ontario market. So they adopt that framework. That framework uses higher water rental rates to calculate the rents. So it calculates rents by assuming how much higher we could have charged, excuse me, how much higher the water rental rates could have been. So that's mechanically, that's what they did. They raised the water rental rates to capture those rents, and they use that to estimate the revenues, estimate the water rentals. The degree that they raised the water rental rates up was based on a benchmark framework where they looked at substitution from other products, and I'll talk more about that later. So how they went about finding that higher rate is something to get in later.
At this point, we're talking about Gillen and Wen.
Actually, we're talking about
Stiglitz and
Hutchings'
Hutchings.
analysis, which adopts their philosophy, their approach.
Okay,
So we're really talking about both.
okay,
But I'm talking, what matters here is how Mr. Hutchings did it.
got it.
So in this slide, that's what he did. And I have the second major bullet here with a lot of references to the work papers. I'm not going to go through those work papers in all those quotes that are there. But if one dives into the work papers, you will see that in my mind, the entire characterization is this is what would have been received by the Crown had water rental rates been charged, higher rates been adopted. There's calculations of how he comes up with those numbers, the higher rental rates. It's showing the collection of those rates. It's framed as rentals the Crown could have collected. There's water rentals under alternative rent capturing rates and titles of tables. All the analysis and framework is on that basis. And I've gone out of my way to put all this detail and reference here because there was a bit of confusion between myself and Professor Stiglitz and Mr. Hutchings about what they did, what I put in my report, what they put in their reply report back and forth. I understand they were dealing with this conceptually, and I saw that their analysis talked about these rates as if they were charged. It is their position, and I accept that they don't assume that these would be charged. So it's a strange situation, frankly, that they frame the analysis as if they were charged, but don't assume that they would have been charged. And that's how we got into this back and forth. I think all the points I made are valid either way, but I wanted to make it clear that's what they did. So in this section of my demonstratives, which we're done with, really is to make a bit emphatically their definition, which is what the Crown could have collected. Their analysis looks as if they are deploying a rate and what could have been collected. And that's how they go about capturing and determining water rental rates.
Thank you. So we go to the next slide, 22. So we move on to the next section, 3B, errors in the calculation of economic rents for hydroelectricity. And then the first slide that follows that, you've titled it Major Errors in Hydroelectric Economic Rent Analysis in 3 Areas. Can you explain what you're conveying here on this slide?
Yeah, this is an overview of this section where I talk about these 3 errors. These are errors that relate to their application of the Gillen and Wen approach. There are other approaches. The grant report that they cite talks about a more detailed analysis that might be done for economic rent determination and maybe is much more sophisticated analysis. So there are other things that could have been brought up here. But according to the approach they took, they said they applied. It is my conclusion they made 3 major errors, and this is an overview. The first is the reference price error. The reference price error relates to how much higher they thought the water rentals could have been and how they determined that number. They set a number that was too high using a flawed methodology. The second issue has to do with consumer demand. If you want to know how much water rentals could have been achieved by having a water rental rate, we need to know how much was generated. Early in the discussion this morning, I talked about hydroelectricity in Ontario was developed to follow consumer demand. We built as much generation as we needed to serve customers, and customers decided how much really hydroelectricity would be produced based on how much they needed. So the demand element is an important part of the water rental revenue calculations. And for reasons I'll get into, they used a number that's too high. They used a number that doesn't reflect proper use of the Gillen and Wen methodology or anybody else's methodology for calculating economic rents.
And so the error in B is the same as the error in A in that they set the number too high. And in A, it's call it a reference price error. And in B, it's the consumer demand.
Well, if we think of water, the economic rents from hydro as a price times a quantity,
Mhm.
A relates to the price. They use too much. And B relates to the quantity. So they're multiplying too high a price difference times too much quantity of hydroelectric generation.
Too high a price difference or too high a price?
The the rents are associated with a price difference.
Okay.
You know, it's the, if
It's the
rents are
pri- it's the
excess profits. Yeah,
Got it.
it's that excess
Thank you.
or uncollected rent, which is a term I'll be using more of here.
And the third error you've outlined in this slide?
The third area I call practicality error. It's one thing that after the fact to look back and say, oh, this is a rents that could have been collected. It's quite another to think on a going forward basis in the real world, what you could have done and how you would have collected it. And so there's a number of issues that are wrapped up in that practicality error.
In case, in the event that it's possible to avoid going over something we don't need, I asked the question. Is there in Professor Stiglitz, I believe, is there any suggestion that this was collected or could have been collected or should have been collected? And the answer I understood was no. This was a concept to value, to come up with a value. Not saying what the Crown could have done or should have done. Am I misstating the evidence or misunderstanding it?
Well, I don't want to try to represent what Professor Stiglitz said on this topic. But if I understand his question right, is the concept of economic rents at a very high level using different language, I think is something people were generally aware of. And there's a quote I'm going to get to from 1898, which doesn't use the economic rents concept, doesn't use the economic rent jargon, but does show there's an interest in collecting money from things like, well, from hydroelectricity specifically.
Right.
So the idea of collecting money from this thing, natural resources, I think is present back to 1850. I mean, that's before hydro, obviously, but there's Professor Stiglitz's report talks about, and I believe to be true, that they were collecting some money. That money they were collecting was some of the rents. The question is what Professor Stiglitz is introducing is the idea that we should collect all of the rents, or we should be aware of all of the rents.
I think it's the latter, and that this was a subject of much cross-examination. Just this is my understanding of the evidence. This is a concept to be used to quantify value. No, that the opinions were not opinions on what the Crown should have collected. The Crown has many different, I'm just repeating the evidence, has many different priorities.
Right.
And they may decide to collect none, some, or all of the economic rents.
Mhm.
But to determine what the value is, this is a useful model. So I just don't want to spend a lot of time on all the practical problems in collecting the rents, because it's not something that the Crown has to answer. Because I don't believe it's an assertion made by the witnesses.
Right. Where I struggle is that, and why I spent so much time talking about in the prior slide that their definition is what the Crown could have collected.
Mhm.
If we accept that, and it's their definition, then there's a role for practicality. Now, I don't want to get wrapped up in
Okay.
minor details, but that's why I spent the time on their definition as it applies to hydroelectricity, because they framed it in terms of what could have been collected.
This is going to
And it-
sound weirder and weirder, but I suppose it falls on a definition of could have collected.
That, And-
Conceptually, I think, I just want to say, my understanding of the position of the Crown is, this is a conceptual framework. It was never, I've said what I have to say a couple of times, so
So I think your last comment, you said the Crown, which I think you meant the plaintiffs.
the plaintiffs. Yes, thank you.
A-
Or
and-
what the Crown could, how it can be viewed in the Crown's hands. But I'll leave that to you. You know what I'm saying, and I'll leave it to both of you to deal with that.
I think you will have some answers as we go through these, but I don't want
Go ahead.
to. So you outlined 3 errors in the slide. Are there other errors?
These are the three that I address. I mentioned a moment ago that there are other approaches one could take to calculate an economic rents, other approaches, other issues. I do valuation exercises. I've done them for real investments, and I model electricity industry at an hour by hour basis, calculating how things work and the implications of all kinds of phenomena. And so there's layers, whether errors or simplifications here, there's other things. I think this is appropriate for the purpose here of evaluating their proposal to focus on these three.
I think it might be helpful, just maybe slow down, just touch for Madam Reporter.
Absolutely.
So let's move to the next slide, slide 24. And it appears you addressed the first error, the reference price error. Can you explain this slide?
So I mentioned this briefly before, the idea of the reference price. The rents that could be collected from a hydro facility are limited based on the ability of the purchaser of the electricity to get it from other sources. This is the essence of the Gillen and Wen approach. And you look in the market for these treaty area resources. If they were to try to capture more economic rents from those, would make them more costly, and what would be the competitive response to that? And the competitive response is the higher price. So the reference price relates to how much higher we could have raised the water rental rate before customers would, in this case, the consumers of electricity acting through HEPCO mostly would have gone to other resources. So we can think of the reference price in terms of that energy rate for water rentals. The reference price is the alternative source of supply. Mr. Hutchings in his analysis looks at hydroelectric power from Manitoba and Quebec. He looks at fossil fuels from other jurisdictions, including looking for prices from 1970 to apply in 1920. So looking forward 50 years, he looks at all those things, but what he doesn't look for and refuses to look at is hydroelectricity from resources outside the treaty area. That's the essence of this reference price error. And I've got several slides on it here. So if we go back to the concept of economic rents, it's what can that owner of that resource, what can they obtain before customers switch to other resources? So the hydroelectric facilities in the treaty area, how much could they raise their price before someone would go to an alternative? And the alternative from the treaty area would be resources outside the treaty area in Ontario.
Now, I know we've gone through your work experience. Have you analyzed the cost of competitive alternatives before?
Yes, that's an essential part of market price forecasting and all the valuation work I do.
And you've just mentioned hydroelectric resources from outside the treaty area. So if you assume that there are no hydro facilities in the RST treaty area, could that area be serviced from these outside facilities?
Yes, we move power on transmission lines over long, long distances.
Now, if you go to the next slide, slide 25. You continue on with the reference price error. Explain what you're saying here.
Yeah, there's a table that I'm concerned is confusing beyond what it needs to be. If we think back to the curve that was presented earlier about the development of hydroelectricity in Ontario, up till at least 1960 and probably 1970, we saw that we had continual growth. And I mentioned that that growth was based on what consumers needed. And we just built it. We built hydroelectric facilities in Ontario as they were needed to serve customers.
This is pre-1960.
Certainly up till 1960, it starts to have some thermal and nuclear in the 70s. I think we pretty much build out by 1970. So it's
Okay,
a gray area. I use 1970 as a break point.
okay.
So up until 1970, we were building as needed. And
We, Ontario?
the Ontario, principally through HEPCO, was building hydroelectricity power plants as needed. They weren't built before they were needed. And as customer demand grew, they had a long list of resources they were ready to develop, and they just developed them as they were needed. To build them any sooner would be, unproductive. It served no purpose. And they kept ahead of it. The way HEPCO kept ahead of the construction schedule is merely the fact you didn't have blackouts. There was enough supply. And so you could see that in the prior curve that we spent time on this morning. And then what I did in this chart here, in the figure on page 25, is that I listed Ontario generation for each year. And then I listed non-Ontario generation. And you compare those two. So for 1923, Ontario had, and I'm gonna deal in millions,
Mhm.
4.115, and the non-RST treaty area had almost that, 4.040. Well, the non-RST treaty area had 4.152, which is greater than what was in the total Ontario in 1923. So what this table shows is that the non-treaty area generation in 1924 was all that was needed to meet 1923 Ontario generation. Now, since we generate as needed, it might have been you could have done this even with the stuff, even with generating capacity that was located in Ontario, in the non-treaty area. But certainly we proved that by 1924, we had enough non-treaty hydro facilities to meet all the demand for Ontario in 1923.
Maybe I'm not understanding how to read this. If I look at 1923 and I look at Ontario generation, let's say I call that 4.1 million.
Yep.
And then I look at non-RST treaty area, 4.0. And you say the non-RST treaty area had enough to satisfy all of Ontario?
The non-treaty area in 24, 4.152,
Yes.
was more than the Ontario in 1923, 4.11.
Oh, you're comparing the non-RST treaty area number
Yeah,
in 1924 to the prior year.
right.
Got it.
And just to complete this, I think I'm going to say, I don't think you're going to learn anything new, but I want to put it this way. So if I look at what was needed in Ontario in 1923, 4115, and I go to the non-RST treaty generation column, how far do I have to go down before I hit that number? 1 year in 1923. And therefore, what
You're saying the capacity was there. to supply.
the energy production value was there, yes. I'm quibbling over the energy capacity and energy,
Okay.
which I said
Right.
but that's where I get the 1 year of acceleration needed in the column on the right. All we could have gotten enough with just the next year's generation. And it's low numbers, certainly throughout the 20s. 1930 is an extreme example, or 1929 is an extreme example. It took 7 years. And so the Ontario generation was 6.45. Non-RST was 6.15 that year. But if I want to exceed 6.45, I have to go all the way down to 1936. And there you have a 7.2. So that's a 7-year delay before we get that. Which sounds, now to interpret this chart,
Sounds like blackouts.
no. It sounds like the Depression.
Ah,
We don't generate what we can generate, we generate what people need. And then the Depression, they call it a depression for a reason. The economy slowed down, there was much less consumption of electricity, therefore less was generated. So we may have had enough to satisfy the generation needed in 1929 from outside the treaty area. We might have had it in 1929. But to prove that we had it, we have to look down until the economy recovered by 1936.
Okay, so just to explain the first four columns, I just want to make sure everybody understands what these columns mean. So when you, on the last columns, years of acceleration needed. Actually, can you just explain exactly what those numbers mean?
That's how many years we need to go down in the non-treaty area generation to find a year where the generation was more from the non-treaty area than the entire Ontario demand in the year in question. So if we pick a year, the year we're studying, how far down we needed to go to find a non-treaty area generation that could have satisfied demand in that year.
So if I read 1929 again,
Mhm.
I see that all of Ontario generated 6.4 million. The non-RST treaty area generated 1.5, or sorry, 6.5. And it took until 1936 to hit 6.4 or higher.
Right,
And that is 7 years.
that's 7 years. That's
Got it.
right.
Thank
That's
you.
how to read that table. You know, that's how to read that table. To interpret these results, it's important to recognize there was a recession. That's why we didn't generate it.
Right.
We're in depression. And that's right. But
So you can explain, oh, sorry.
so I did this for all the years to look at the concept of really what's involved with generating more outside the treaty area. This is an incredibly simplistic analysis because it doesn't look at, you know, for example, what we just talked about in the depression. It misses the point that we just didn't generate it. It was available. We didn't generate it because there was no demand. But even so, it shows that there are just a few years of generation of acceleration. We only have to look a few years into the future to prove that the rest of Ontario had enough hydroelectric capacity to meet all hydro in the province with even without the RST hydro generation.
So you've explained the 1929 depression years. There are other years of acceleration that are 7 years or 8 years. For example, 1942. Can you explain why those numbers would be higher?
I believe that has to do with the effects of World War II on the economy and the amount of, you know, looking and just as a result of it being slow growth overall. If we look at the from 1942 to 1947, for example, in 48, 49. Look at 42 where you start. And looking at the Ontario generation, it's a very slow growth. It's growth because of demand. So they weren't building a lot. It took a while to make up for the fact that 10%, 9% or so was coming from inside the treaty area. But there clearly was enough to build. There is a question about delay, but clearly Ontario had plenty of hydroelectric resources outside the treaty area to generate. The mere fact that by the time we get to the bottom of this overall chart, we're at 36 million megawatt hours, proves that there is a lot of potential for hydroelectric generation outside the treaty area. That potential was always there. Those rivers didn't change.
And just for clarity, is there a relationship between Ontario generation and demand?
Yes, we only generate what we need. Customers decide how much to generate.
So why does this chart only go to 1970?
By 1970, the amount of hydroelectric generation had more or less plateaued. There's still variation from year to year due to rainfall. We saw that in the chart we looked at much earlier this morning where it flattened out. And so if the treaty area hydro had not been developed, there wasn't other hydro that could have been developed in its place to make up for it by the time we're at roughly 1970.
So There wasn't an available alternative after 1970.
The hydroelectric alternative.
Okay, and unless, is there anything else you wanted to address on this slide?
No,
Okay, if you go to the next slide, slide 26. It continues on with the reference price error.
right.
You
So,
have-
I'm sorry.
You have Professor Stiglitz and Mr. Hutchins refuse to consider non-treaty area generation from within Ontario. So what did you mean by that?
Well, this is an error in their analysis. I want to address their comments about my conclusion that this is an error. So this requires me to put up the straw man of what they said and then to analyze what I think about that. So they said, their quote, they assert their analysis is if Ontario did not have rivers that enable hydroelectric generation, that resources would have to come from outside of Ontario. That's true, I suppose. That's just not, it's got nothing to do with what I'm raising as a fact, that the fact that there were hydroelectric generation opportunities outside the treaty area. And I also note here, this must be outside of Ontario. What does that mean? I mean, when they look at other resources like fossil resources, those are assumed to be built in Ontario. So they're willing to look at onto other areas of Ontario for fossil generation, but not hydro generation. I just point that out because I see that further inconsistency. Professor Stiglitz and Mr. Hutchins suggested it'd be better public policy if all hydroelectric generation had the higher water rental rates. I don't comment about public policy in this case and whether that would have been better public policy or not. I don't see the relevance to this case. They don't assert that that had to be done as a consequence of the treaty. And this is this discussion we had a moment ago about not doing that. So I don't know why that becomes a relevant factor here and a basis for ignoring these other resources, which is what Mr. Hutchins does. The third bullet I have on here is just to make clear that there are other studies where people looked at Ontario-wide water rental rates that could have been charged, like the Gillen and Wen study. And if you're going to look at an Ontario-wide water rental rate, as if you're going to adopt that as a public policy issue, which is not the issue in this case, then it would be appropriate to look outside the province, because you're trying to come up with a water rental rate for the entire province. So the number of academic studies that do that, but that's for a different purpose. And I'm highlighting it just so it doesn't look like I'm trying to hide it, that's all. So those are some of the examples, and there's more on the next page.
Okay, please continue. We're on slide 27.
Right. Another excuse Mr. Hutchins provides is says the relevant reference price, this is where we look for the alternative, must be a competitive benchmark. And it must be a price that's absent distortionary policies that affect prices. Thus, the relevant benchmark would not be hydro from elsewhere in Ontario. This is part of his testimony, and I quote from his demonstrative. So the first issue is, my definition of a competitive alternative is a viable alternative at the lowest cost. I mean, this is what a real person would do faced with higher costs for the treaty area hydro. This is a competitive action, is a practical and real option available to them. That's what I view as a competitive option. The next thing he talks about in this quote is that must be absent distortionary policies that affect prices and must be competitive. Those sound, I'm not sure what clarity is provided by that. I mean, electricity is a quintessential natural monopoly. Hundreds of years, in the 1890s, we decided that you needed to have not pure competition for electricity. There is no pure competitive electricity market anywhere. So the idea that we need a competitive benchmark, I'm not sure what Mr. Hutchins, how he's defining that in a way that makes any sense here, but there is no pure competition. We've tried to get more competitive markets in recent years. I've been heavily involved with that process, but it still involves interaction, regulation, monopoly power needs to be controlled, natural monopolies exist. There's no such thing as electricity price that's absent distortionary policy that affect prices. That just doesn't exist. The other thing I found interesting with this recent characterization and is that in looking for a competitive benchmark is that HEPCO, who's the primary owner of hydroelectric facilities in Ontario, they're a not-for-profit enterprise. And so they're not a competitive benchmark. Matter of fact, they have low cost of capital. If we think about the discussion of economic rents that has been presented in this court by multiple witnesses, they talk about you need to have a normal rate of return to investors. Well, HEPCO is below that because it's entirely financed at rates based on debt to the province. Mechanics of that are more complicated, but there's no equity component, and it's borrowing at a cost far below a competitive person could borrow. So we're already starting, with prices below what you would get in a competitive environment, and it's done for public policy reasons that make sense. But I don't know what Mr. Hutchins is ignoring that in his calculation of economic rents, and yet then claiming that we need to have a competitive benchmark here. It just doesn't hold up. And then the other thing is he relies on electricity prices for Manitoba and Quebec. Well, those aren't competitive markets. I could argue strongly that recently Ontario is a more competitive market than Manitoba and Quebec. But either way, those are not competitive markets. They are provincial owned entities or the equivalent. It's also true, Quebec can't deliver electricity to Ontario.
But is Manitoba, for instance, where, no matter whether it's called a competitive market or not, is it an alternative market, an available alternative market?
It is, there is some limited capacity to get electricity from them. There isn't from Quebec. It's
Because of transmission?
because, yeah, the way for engineering transmission reasons, they're not integrated and therefore you can't move the power. So this competitive benchmark, I find lots of issues with his phrase. That's what it needs to be. There's also a phrase in his demonstratives about it's unreasonable. He references alternative generating technology in the 1916 to 1976 period. I want to address that because that's why he says you can't look elsewhere in Ontario for hydro. But I don't know what it means, why we would be forced to look at an alternative generating technology. I mean, the alternative technology would be, for example, coal or some other fossil fuel. That's the kind of thing we're talking about here. But I don't know why we would be limited to that. I see nothing in this case that says that for reasons having anything to do with the treaty and the treaty areas, that people can't do hydroelectricity in other areas, that we have to just use coal, for example. So I'm trying to address the objections he made. I don't understand it well enough to fully flesh it out. I just don't think it makes any sense.
So before we move on to the next error, I want to try to assist the court in the earlier question. If someone were to try to calculate economic rents, would this reference price error still come into play? Even on a conceptual basis, sorry.
Yeah, yes, if you're calculating economic rents, you need to have a reference price. You need to figure out what the alternative was, whether you're collecting that money or not. If you're just calculating, you need to have the alternative. The alternative is something outside of what you're correcting the rents on. So if we're calculating rents in the treaty area hydro, we look at all other available resources outside of that. And then this error exists in the analysis Mr. Hutchins did.
Thank you. So before we move on to the next error, it may be a good time for the afternoon break.
Right. Good.
All right.
All right.
Thank you. Mr. Hamel, was there anything else you wanted to say about the reference price error before we move on?
No,
Okay, so let's go to the next slide, which is slide 28. And here you are addressing consumer demand error. Can you explain this?
yes, to return to the conversation we had before the break about water rentals overall, it's a factor of a price difference, and the reference price had to do with that P, that price. And now we're dealing with the quantity. The amount that water rentals, the quantity of hydroelectric generation that Mr. Hutchins assumes for his calculation of of economic rent is too high. He uses a excessive level of consumer demand, which is associated with an excess, therefore an excess level of hydroelectric generation for the calculation of economic rents. That's what this slide's about. So he uses a water rental rates that are substantially higher than the actual rates. Now, I take a different view of what those rates should be. That's the first error that we talked about. But now I'm returning to his assumption that that's the rate that should be used for the calculator of economic rents. And then I consider this demand question, or the quantity of hydroelectric generation. And he assumes there's no change in demand, the amount of hydroelectric generation or demand at the lower price or the higher price. The fact that we now are trying to collect so much more money through economic rents doesn't affect the amount of demand for the products. And that's an error in terms of how one goes about calculating economic rents.
The error is to assume that the rates will not affect demand.
Yes. Better put than I did. So on the right-hand side of this table, I look at the differences, the average water rentals for different time periods, or the first column, and you can see the different breakout of periods that I have there. Those are the time periods that, and how it's structured for Mr. Hutchins' analysis. I adopt his time periods there. And then I look at the average economic water rents that he proposes. So we see in the earliest years, it goes from a penny to $1.30, and it's actually an increase of 162. This is a major change. And you can see that it's biggest in those earlier years, but it's still significant for all of these time periods.
Sorry, when you say an increase of 162, did you mean in dollar cents?
Multiplier. It's $1.30 is 162 times the 1 penny, properly accounting for all the decimals that were in the difference between these two times, what did occur and what he thinks would have been associated with connecting economic rents.
Thank you.
So I look at the water rentals themselves. Of course, consumers pay for electricity. So I look at the rates HEPCO charges. HEPCO, of course, is 90% of the generation, and that's where we have the data. So in the table below that, I go about calculating the revenue from the electricity, revenue with the higher rates, and see how much electricity prices delivered by HEPCO would have gone up. And we see that it goes up some 23, 22%, 31%, down around 20% at the end. So this increase in water, changing the water rental rates to capture rents as proposed by Mr. Hutchins and as he done his analysis, would be associated with a 20 to 30% increase in electricity prices. And consumers respond to prices. The economists call that elasticity of demand. It's studied in lots of different ways. This is an error that they did not include this in the analysis. Let going back and forth through our different reports and reply reports, Professor Stiglitz and Mr. Hutchings, acknowledge that consumers purchase less when prices are higher. I'm glad they acknowledge that. That's not in dispute. The dispute is what's relevant, how to go about calculating economic rents in this case. And that's where the bottom section here with all the sub bullets is to support my position that you need to calculate economic rents with demand associated with customers paying that price. That's the right methodological way to do the analysis. If you think about it, if we define rents as rent that could be collected by the Crown, then that has to be collected. It has to be what customers pay. So we need to reflect what customers pay and figuring out how much the Crown would collect. So that's using their definition and looking at it closely to support my contention that you need to look at the lower demand associated with these higher price. Another definition of rents that are used often is the excess profit to a firm. Well, the excess profits of the firm come from charging those rates to customers. So we need to consider that. So that's another definitional perspective on why this is the right level. It's also consistent with the methodology used in the studies that are referenced by Professor Stiglitz and Mr. Hutchings. I went through this in my SIR reply report in some detail. This includes the Gillen and Webb article I talk about. That article is about 10 pages long, and fully half of that article is about how we consider price effects of changing water rentals and what that will do to different sectors of the economy. The professors who did that took out 25 different sectors of the economy, whether that's whatever those are, industrial, forestry, whatever, and thought about price elasticity in those sectors to figure out how much change and what the effect would be. They also have supply and demand curves that lay this out in detail and showing how, from a conceptual standpoint, how price affects demand and how you need to consider that. So despite relying on that article, Professor Stiglitz and Mr. Hutchings in his analysis ignore this price effect, which I find a flaw with. I also mentioned, if you look at the second to last bullet here, this is consistent with all the methodologies of the independent studies referenced by Professor Stiglitz and Mr. Hutchings. They rely heavily on the Gillen and Webb paper, but there are others that they reference having to do with hydroelectricity. And there's a number of those. I've been through all of those. Some are quite explicit about how they handle this issue. Some are more, well, we're going to hold demand constant. And it's phrased in a way that makes it apparent that, to me at least, that this is a simplifying assumption, but they know that they need to call that out because that's not real. So I view all of these studies recognize that you need to you need to calculate economic rents with demand associated with prices where that rent could be collected. So all of the studies do that.
And on the next slide, continue on with the consumer demand error.
Yeah, so if you correct this error, you need to consider price elasticity, how much demand would go down. And in thinking about it, I have not done that study. I've been involved with cases where people look at different elasticities of demand. There's short-term elasticity, there's long-term elasticity. Here we're dealing with a 100-year time frame. The interesting thing is today we're pretty indifferent to what electricity price is, not entirely, but certainly when we walk into a room and decide we want the lights on or perhaps off to save heat, we don't consider the electricity price at the time when we make that decision. But if you go back to the 1920s and 30s and 40s, when people were converting to electricity in the first place, that trade-off was very much on their mind. What they had was working, and whether they wanted to take that commitment to converting their processes, whatever they were, into an electric-based process, this would have slowed that adaptation. And if it slowed it in 1930, get away from the Depression, in 1940, then it also means 1941 would have started with a lower level of demand when people are making decisions in that year. So throughout this period, especially in the earlier years, this is a significant issue. It's just an error.
Isn't that presuming that everything else stays the same? But in the 20s, 30s, and 40s, as you say, people were transitioning methods,
Right.
and there was a complete revolution in how work was done. So price wouldn't have been the only consideration on consumption.
No, it wouldn't have been. It clearly wasn't. I don't mean to give that impression. But if we look at the world as it was in those timeframes, people in real time were making this decision. And
Well,
now
are we
we,
talking retail consumers or industrial consumers?
everyone. This is demand. I'm going back to consumption of electricity, which is the
Mhm.
hydroelectric generation up to 60s and 70s for sure.
Mhm.
And there were choices made. The reason that grew so much was about people adapting electric technologies.
Mhm.
And those decisions were made by everyone, industrial firms, locating factories, consumers deciding whether to buy a washing machine or not, all those factors.
Okay.
And on the margin, the price matters. And people make a decision. If you think about another way to consider this at a conceptual level, is someone might decide they want to get a washing machine for their clothes, an electric one. And that they're going to make that decision on some day. They might have wanted it for a long time before they make that decision. And they might ultimately end up with an electric washing machine. But if the price for electricity goes higher, that decision might on the margin come a little bit later.
Could also depend on whether that they just got a job. Just leave that with you.
It could be. True. And the last bullet I put on here, and I'm just want to make clear that there are two errors I've talked about. One is the reference price, where you would build the alternative resource, and then this demand response. And there's interplay between these two. If we accept what I said about they could have built in other parts of Ontario rather than the treaty area,
Mhm.
because it was readily available, well, then there's not a lot of price effect in that time period. Because the non-treaty area hydro cost about as much as the treaty area hydro. And so there wasn't much opportunity to create more rents by raising prices in the treaty area, and therefore prices to consumers don't change very much. If you rule out that option for whatever reason, then we end up with closer to what Professor Mr. Hutchins calculates is the reference price. Then the consumer price for electricity is what we just talked about, and then the demand response is more significant. So there's the interplay between these two. And it's also true as we get to the later period, as we build out hydroelectric resources, then this becomes a factor no matter what.
Go ahead.
And in the next slide, slide 30, we titled it Flawed Responses to Excessive Demand Assumption Error. What do you mean by that?
Well, I did something similar with the reference price error. I see this as an error. I've looked at the response of Professor Stiglitz and Mr. Hutchins to this error, and I need to present it and then talk about why it's not applicable or why it misses the point. In my initial report, Professor Stiglitz and Mr. Hutchins dismissed these claims by saying they followed a standard peer-reviewed methodology.
So can I say that this is a response to their reply
It's both their reply.
or to their reply?
Yeah, their reply. And yes, this is a response to their reply. I'm trying to think if there's any, if this is a response to their live testimony as well.
Okay.
And it's, yeah, I break that out because I don't believe they really addressed this in their live testimony, which is perhaps another factor worth considering.
Okay, and when you say this, I did interrupt you, so I'm sorry. You say, I don't believe they addressed this in their live.
The excess demand, what I call the excess demand error,
Got it.
that they don't address that in their live testimony. Okay, now returning to the elements that they do mention in their report, their reply report, as the first bullet mentions, they dismissed my criticism by saying they use standard peer-reviewed methodology. But they don't reference the fact that every study they reference, they don't go beyond saying that they did that. I've just pointed out that every study they look at considers demand response and considers calculation of economic rents at the point where, at the demand point where those rents are being collected. So that's my response. You can claim you did the standard review, peer-reviewed methodology, but you didn't. And then the next point is we do not require the Crown to collect rents. I understand that, and that is at a very high level, a difficult issue sometimes for me to get my head around. I understand it. The court has already raised that. I understand that's a relevant issue here. But the fact is, whether they decide to collect them or not, this is how they should be calculated. That's the point. The fourth point, the third point is they do a rather extensive discussion about how prices could be kept low through subsidies. And maybe they did include this in their live testimony. I don't recall. I don't have it referenced here. But could you keep the prices low through subsidies? So that's the actual demand. And of course, they define a subsidy as charging less than the full capture of economic rents. And they go into all this calculation of subsidy. Number one, that doesn't capture the proper way to do this. It doesn't get you around the proper methodology. And number two, I conclude that a subsidy is either, and I use these words deliberately, either nonsensically irrelevant or impossibly hard. Those are two extreme statements. I recognize that and I stand behind them. In order for this to work, to have zero effect on consumer demand, you've got to have a subsidy match up so that the prices are exactly the same that existed in the actual world. And I can see two ways to do that. One is when you charge a water rental and you increase the water rental rates to capture rents, at the exact same time, you give a subsidy that exactly offsets it for the money going back. And so it's either two checks cashed in the mail that directly offset each other. It seems to me that's economically irrelevant. I don't know that it's a thought experiment perhaps, but it's nothing more than that. It's not a real thing. The other way to do this is a subsidy through customers.
Oh, okay, go ahead.
And if you want to do a subsidy for customers, if you want to subsidize, and I hear residential consumers, et cetera, and they talk a lot about how you could do that. It's important, if you don't want to have a customer response, that each customer pays the exact amount that's embedded in their bill. And bills include hydro, they include a different distribution of fossil and nuclear. You'd need to find out exactly how to do that in each case. I don't know how you would make sure that each customer bill properly reflected what element of that bill reflects the increased economic rents that they calculate. It's you have an extra rate. It goes in now as an overall cost of electricity, but every person's paying a little bit more because they're buying different quantities, they're buying at different hours. Prices for electricity vary hourly, and getting that to all match up seems impossibly hard to me.
The airlines do it. There's not one price that any two people on the plane pay the same.
Right. Yeah, no,
They manage.
well, no,
Sorry.
no, they manage to come up with prices to different people for different times. What I'm saying is what's being proposed here. I don't know how, I'm not going to try to work through to the airline example. Customers pay all kinds of different prices. And what Professor Stiglitz, Mr. Hutchins are asserting is that we could figure out how much of each bill was associated with the extra rents, and then offset that in real time so that the behavior of that customer doesn't change. We can get the totals pretty easy, but now we have to figure out every single customer, every different rate structure, every different retail arrangement, and make sure that they get a subsidy exactly matches it. And that's what I'm calling is impossibly hard.
When you say, so the behavior of the customer doesn't change, are you referring to usage? Is that what you're referring to?
Yes, the demand, the usage, how much they consume. So, they talk about in this third, what I've labeled third, they could have been kept low through subsidies. I talk about the challenges there, or nonsense perhaps. The next is, they characterize these prices as having an implied subsidy. Still doesn't change the fact that the way to calculate rents is where customers pay the right amount. That's the theory. They've brought that theory to this case. That's how it should be done. And the third thing is, if we imagine that those subsidies are necessary to get the demand that we need, that the Crown is incurring a cost of those subsidies so that demand will be the level they want. Well, it seems to me this now becomes an expense incurred by the Crown that's associated with hydroelectric generation. I agreed with Mr. Hutchings, accepted as reasonable, Mr. Hutchings' expense determination at 2%. Earlier, that was a different circumstance, but now we're claiming that there's this subsidy that the Crown has to incur, and the subsidy is related to economic rents. Well, then the cost of the subsidy is part of that. It needs to be deducted. And when you deduct the cost of the subsidy as an expense related to economic rents, we're back to the NCRRs that Mr. Hutchings calculated, because they offset each other. It's just sort of a logic where you end up if you try to adopt that approach. So that's my third item about the subsidies and trying to address which they have raised. The fourth, and I go back to the original report, and I've quoted it here, maybe can perhaps highlight it, but they seem to have abandoned this claim, but they asserted in their first report, such a fee would be well within the margin of what the Crown could have collected without distorting incentives for investment or development. Well, I started this by showing the price change, talk about how consumers respond to prices. Professor Stiglitz and Mr. Hutchings acknowledged that there was a price response, and they seem to have walked away from this statement that was in the original report. But this is the problem I have in responding to this overall theory, is that the target keeps moving. They made this statement. They seem to have backed away. I don't think the statement's valid. It's on my list of excuses that they've come up with over time. I don't believe they're standing behind this anymore, but trying to respond to this stuff is a moving target.
So I think you've already answered it. I just want to make sure we're responding to the court's earlier question. If you were to calculate economic rents, even on a conceptual basis, would this error come into play?
Yes, you need to calculate economic rents using the proper methodology with demand set at the price that includes those rents. So this is very much applicable there.
Now, on the next slide, slide 31, you address what you call the practicality error. Can you explain what that is?
Yes, and I've given consideration to the discussion we had earlier about this being a theoretical concept, not necessarily implemented. But if it is something that could have been collected by the Crown, it had to have some elements of practicality to it. And that means it isn't just a theoretical concept. It was Professor Stiglitz's definition of what could be collected. And one of the elements of that is collecting water rental rates on a going forward basis. People need to make decisions and go forward. And the other is we need to consider the response of the market to those rates. And I have a very specific example on the next page that I think is worthwhile. But here is at a very general level, if we think back to all the variations in water rentals rates that I went through with all the agreements that we talked about this morning, those all existed for a reason. The Crown was doing that for some reason having to do with what it thought was appropriate for each power project. They all had different lengths and durations, which I believe is related to the characteristics of those power plants. So what we see in the history is the Crown taking actions to reflect varying circumstances And those are practical considerations. We know what actually was done and how it could have been done. And it was done on a going forward basis. Just sitting back afterward and coming up with numbers runs the risk of just missing practical issues. And we have a very specific example on the next page, but that's what I'm getting at with respect to this issue in general.
Well, are you saying there's never a time, never a circumstance that the Crown could have collected more, that they have constructed the perfect economic model to get the most they could from the customers to buy or not buy washing machines, or to convert their plant from making horseshoes to making wheels, that they have thought that the Crown's system was perfect?
Absolutely not. That's not what I'm saying.
Okay.
Not at all. And let me make one thing really clear. My report, I have a very specific statement that the Crown could have charged more. That there's not a perfect amount. And especially when one looks after the fact, one can find opportunities to have charged more. I'm not saying there's a hard limit to that. But I am saying that when we try to figure out the theoretical maximum amount of money that could have been made, and that is not a bad definition of economic rents. The maximum amount of money we could have made, that you've got to deal with some element of practicality. You have to have been able to make it. You know, what we could have made has an element of practicality in that definition. And that's what I'm referencing here. A key part of that is going forward, dealing with individual projects. If you raise rates to a bunch of projects that couldn't afford to pay for it, but one, it discourages one from being developed, then that's an issue. I've talked about a specific example, and that's on the next page. Perhaps we can.
Let's go to that. We're on slide 32. So please explain this example.
Yeah. This is the example that it took a while for this to sink into me, frankly. And you sort of have to step back and think about what we're doing here. In 2001, as I've mentioned, there was a rate change, a fundamental restructuring of water rental agreements. And through legislation, if ever there was a time to raise rates, that would have been it in this entire history. You could have done it. We did all the actions in way the entire industry was being restructured. This is when the Gillen and Wen paper was done. And according to their analysis, there was an opportunity to substantially increase water rental recommendations. So a couple points to make about that. Number one, just for whatever reason, the policy was not adopted to raise rates according to what Professors Gillen and Wen came up with. That doesn't disprove those rents were there, but it does say that with this information, policymakers at that time chose not to raise rates as they suggested. There were other factors. I don't know what role Gillen and Wen papers made, but clearly an Ontario study like that at that time, people would have been aware of it. So it wasn't done. What's interesting though, and I'd like to highlight the next major bullet here. Despite relying on their article for methodology, Professor Stiglitz and Mr. Hutchins conclude, for those years where we lack reliable benchmarks for rents, 92 to 2019, we conservatively use actual water rental fees collected by the Crown. Now, this means the economic rent theory doesn't really play a role here. The uncollected rents, the above amount we actually collected, aren't a factor in this time period. And that's fine. And I'm not just, that's where I think we should be anyway. So I'm not disputing that conclusion, but I'm diving into what they really did. I want to talk about practicality issues. And they are rejecting the benchmark used by Gillen and Wen as unreliable. I was cautioned about the use of reliability here. This is Professor Stiglitz used this word, that Gillen and Wen was not a reliable benchmark. And so what academics at the time thought was a reasonable basis to try to promote a public policy to change the water rental rates, that's a going forward assessment. Looking back now, Professor Stiglitz and Mr. Hutchins conclude that that's not a reliable approach, a reliable benchmark. adopt the approach. But so it is, to me, it's really somewhat breathtaking to say that the paper they find most influential doesn't use a reliable benchmark. And the reason that I see is it's the difference between looking forward and looking back. And that's why I say we have to deal with a practicality issue.
Did they say Gillen and Wen was too high or too low?
They don't say. They say, let me back up to answer that question. There clearly was water rentals that were collected. We know that. Rents are above, uncollected rents. They have not raised anything above that. They believe it should be higher. They always assert there's more economic rents they haven't collected, but they don't go on to say whether they thought Gillen and Wen was too high or too low. I mean, it's substantially higher. I think you'd have to make a strong case that it should be higher still, but I don't see Professor Stiglitz and Mr. Hutchins giving any view as to whether that number was, other than the approach they didn't adopt the benchmark. They couldn't come up with any number. They go on in their paper to talk about reasons why they thought it should be higher than it was actually, that it's conservative to use just the collected water
Actual.
rentals. Yeah, I mean, they should be more. And let me be clear, you could always find a way to raise numbers a little bit. I mean, to reflect back the comment you made, is the Crown perfect in coming up with a number at all times? No, you could do more, but they didn't come up with a reliable benchmark to be able to calculate it. And they, in essence, rejected the benchmark that Gillen and Wen came up with and the approach that they came up with. And I highlight this because of this practicality issue. It's easy to look at something and say, oh, from a far distance, I can come up with what it should have been. It's much, much harder in real time on a going forward basis with influencing people, with the consequences of severely disrupting your industry, your economy, to come up with a number that makes sense. And that's the trade-off I'm making here. They go on to talk about, I look closely, there's not a lot of detail in the Stiglitz and Hutchins report as to why they abandoned this benchmark and approach. But they do say it's due to technological, institutional, and practical factors relating to the changing power generation environment in Ontario. That's that last bullet. Perhaps we'd highlight that. They talk about technology, institution, and practical factors. In a way, that's what I'm talking about, practical factors. They're acknowledging that's important. They're saying that's getting in their way of coming up with any benchmark. I think one could do it when they consider those
But they're
factors.
getting to where you want them to be anyway.
Yeah, for this particular
Nominal
period.
rate.
But here's the interesting thing. We do this in 2000. I mean, I was working in this industry in 2000. There are people we could talk to about how to come up with it in 2000. They don't find technological, institutional, and practical factors a barrier to doing this in the 1930s and 50s, when there were changes going on in the industry of all sorts, but it's a distance. It's easy to look back and say what should have been done back there. You're not confronted by a deep understanding like we have today. I believe it's harder to know what alternatives were, for example, back then, to understand alternatives today. I know how the market works today, and we have to try to understand what was going on in the minds of policymakers, alternatives for generation back in the 20s, 30s, 50s, what have you. So the basic issue about technology, institutional, practical factors are always present, varying degrees, but they reject it when we have people around we could talk to about those issues. They don't reject it when it's so far long ago, there's no one, frankly, alive that could challenge it.
One clarification, Mr. Hamill. I believe the word that was cautioned earlier today was relevant, not reliable.
Thank you.
Is there anything else you wanted to speak to on this slide?
No.
The court had an earlier question about the practicality area and how it's relevant. If the court is satisfied with the answers given, or we could explore further into it.
Go ahead.
On your next slide, slide 33. It's titled, Economic Rents Are Much Lower Than Calculated. Can you explain this?
Right. I am now going to review these three errors and the implications they have for the analysis. To do that, I have presented on this page figure or table 5 from the Stiglitz-Hutchins initial report. That's their analysis. And they present their treaty area hydroelectric rents by decade. They present them in nominal terms, and then they put them in 2020 dollars. For this discussion, I'll look at the 2020 dollar column. They escalated a rate materially higher than what I did with the corporate bond rate. I'm not offering an opinion about rates. I just wanted numbers so we could talk in practical sense and get a scope of what's going on here. And as I talk about this, I want to, and I'm going to use this term more, it comes up. I want to talk about the uncollected economic rents. It's my position that the hydroelectric rents that were collected were, I'm sorry, the water rentals that resulted in revenues to the Crown, that those were some of the rents. And this whole discussion of economic rents put forward by Professor Stiglitz is to raise that number to get at the uncollected economic rents. And I find this term useful to talk just about that. So if I look at this column about economic rents and I look at it by decade, the first note is that the last 2 decades, there are no uncollected rents there. Those are the water rentals that actually were collected.
There aren't, it's not that there are none. They're not finding any, they're not taking a view on them. Is that a better way to put it, or is it, or
I
does one
appreciate-
conclude that there are none?
I appreciate the opportunity to clarify this. Their calculations do not calculate any uncollected rents.
Okay,
Their position is there are some. I don't want to
okay, that's what I thought.
disagree with that. They clearly, and they talk about that and present discussion of it. They find themselves unable to calculate those values.
Right.
And but if we're dealing with, the numbers they put forward, there aren't any for those decades.
Right.
The next thing, of the $48.7 billion on this table, a little over 70% were up through the period of 1970. And the period up through 1970 is when those first 2 errors are most significant. There's opportunity to build outside of the treaty areas at a much lower cost than the reference price that used by Mr. Hutchins in his analysis. And therefore, with that understanding, the uncollected rents would be dramatically lower than the numbers here. There's always a possibility that they were higher than the actual collected rents. This is the point courts made about the fact that it wasn't perfect, but it's nowhere near these numbers because these numbers are inflated by the unwillingness to look for hydro resources outside the treaty area. And then as that interplays with the demand assumption. And the demand assumption, as we start to use up all the hydro outside the treaty area, then the price would rise as you start to increase water rentals, but then the demand factor becomes a bigger issue. It plays a greater role in drawing the conclusion these numbers are inflated. That leaves the 70s, 80s, and 90s. The errors are still significant. I find the practical considerations start to play a bigger role. Doing this on a forward basis, we saw that in 2001. There's an interesting debate issue about the 1990s. Mr. Hutchins calculates substantial uneconomic rents, uncollected economic rents in the 1990s. You see the $3.2 billion in that column. The collected rents, we don't have the number here. It's probably in the neighborhood of $300 million, 10% of that, roughly speaking, very, very roughly speaking. But he calculates a large number, and his work papers show that.
And can you tell me what the number is, just so I see where you're speaking?
as written, it's 3,205.
Got it.
That's $3 billion.
Mhm.
And so he calculates this big number. But in his quote I gave at the prior page, they said they do not have a reliable benchmark for 1992 and beyond. So we have, according to their report, Mr. Hutchings calculating a large number on the basis of an unreliable benchmark. I made a point of this in my reply report. And my initial report and SIR reply report, and we haven't heard anything to address this issue at court. Is it a typo? I know that there are other places where I concluded from the work papers, they must draw conclusions about the demand assumption, et cetera. And in reply, I was told to made quite strong that don't look at the work papers, but to look at the actual written report. That I was wrong to look at the work papers, for example, that said this money would be collected, because that's how the work papers read. And I understand, we've talked about here that that's not what they meant. So you can't go to the work papers to find the answer. In this case, the work papers calculate this big number. But what the report says, and they didn't contradict or fix a testimony, is they didn't have a reliable benchmark. That's their word. So anyway, that's the 1990s. That leaves the 1970s and 1980s. Those are the decades that I believe the economic rent theory would result in the greatest amount of uncollected rents. That's the area where it would be more than was actually collected as a result of the build out of hydro, other resources coming in. But I think their analysis is flawed for the practicality reasons, for the demand assumption reasons, and even those numbers in those years are too high.
That takes us to the end of this, the errors section, and I know it's 4:30 at the end of the day. It looks like I have about an hour left, so it's likely a good time to break, and then we'll finish it tomorrow morning.
All right. And how does that work with you? What your plan is? Anybody else? Nobody else jumping in on this? Okay. Great. I think that is a good time to break then. I'm just going to catch up for 1 minute. Yes, thank you.